For this year, the same as last year, at least for the beginning of the year, I think. I don't know if it'll last until June or not, but we expect the same as last year, which means that USCIS will mostly be sending RFEs if they do send RFEs, and we haven't received many RFEs last year. They will send RFEs on specialty occupation. They might send RFEs on maintenance of status. They may not send that many RFEs on availability of work. Now, that's a big issue, availability of work, especially in consulting situations or in IT company situations where the person is consulted out to a third party, and also in situations where you're actually working for the client. They want to know if the employer has sufficient business to require that job in the specialty occupation, if they have enough availability of specialty occupation work. Now, this was a huge issue in the previous years, but as a result of, in 2020, there was a lawsuit, ITSO versus Cessna, as a result of which USCIS is asking that question less and less. Otherwise, they would ask for purchase orders, contracts, proof of doing business, and they would also ask for, especially in consulting company situations, POs for the entire duration of the 3 years. If you're applying for a 3-year, if you're applying for a 3-year extension or a 3-year H-1. Not so much now. Last year and this year, there are a lot of IT companies that have filed skeleton petitions, and they've been approved without a PO, without an MSA, without mentioning a client, and USCIS has not sent RFEs on those cases. They've sent RFEs for other reasons, but I have not seen RFEs for lack of POs or MSAs. But having said that, there is a new proposed regulation that's coming up. And in this regulation, the plan is to bring back those POs, the request for POs and work orders and MSAs. So the availability of work, RFEs, might come back again if that regulation is passed. It's right now a pending regulation. Part of it has been passed for the registration, to change the way registrations were done. Now we know they're beneficiary centric. It was part of the same regulation. So they've fast forwarded that portion of it, but the other portions where they're asking for information and some changes with specialty occupation, etc., they have not yet finalized them. They have not published them. So let's see what happens. If that happens, then we can expect a change this year itself in the way CAP cases are filed. So far, so good. My only advice to you is file as soon as possible before the new rule comes out. File in premium processing so that you don't get affected when that new rule comes out, because it's only a question of when. Don't forget to subscribe to our videos if you like what you see. Also, give us a thumbs up and share the video with your family and friends. Thank you.